the Philippines' #1 news channel. Ito ang GMA News TV.
Magandang hapon po! Magsisimula na po sa ilang sandali ang Day 17 ng makasaysayang impeachment trial ni Chief Justice Renato Corona. Ako po si Vicky Morales.
Samahan niyo po kami muli sa special coverage ng GMA News TV. Ako naman si Ivan Mayrina at ito ang The Chief Justice on Trial.
At patuloy po tayong magbabantay sa mga pinakamaiinit na pangyayari sa Senado.
At magulat mula roon ang ating kasamang si Joseph Moro.
At para sa mas malalim na pagtingin sa mga legal na proseso ng impeachment trial ni Chief Justice Corona, makakasama uli natin sa studio si Attorney Pacifico Agabin, dating Dean ng UP College of Law.
Magandang hapon po at welcome back, Dean Agabin.
At puntahan muna natin si Joseph Morong sa Senado. Joseph, kamusta na?
Vicky, inaasahan na magpapaliwanag yung prosecution in open court kung totoo ba or peke yung mga bank documents na inattach nila doon sa kanilang request for subpoena sa Senado. Kahapon kasi ay sinabi mismo nitong si PS Bank Katipunan Branch Manager Annabel Chongson na tila peke raw yung mga attachments at para sa subpoena galing sa Senado. Ito yung customer information card at yung specimen card na umano ay kay Chief Justice Corona. Pero para sa prosecution ay baka raw nagsisinungaling lamang yung mga opisyal ng PS Bank. Ito ay ayon kay Representative Ray Umali. Nanindigan pa si Umali na may small lady na nagbigay sa kanya ng mga bank records ni Corona. Sabi ni Umali ay baka raw hindi covered lahat yung areas dito ng Senado ng CCTV. Pero nang tanungin kung saan ba niya nakita talaga itong small lady na ito, ay hindi na daw niya ito maalala. Sabi naman ng depensa kung mapapatunayang peke yung naging basehan ng subpoena para sa mga bank accounts ni Corona, ay pwede raw nilang ipa-strike out sa record yung testimonya at mga dokumento kaugnay ng bank accounts ni Corona. Narito ang ilang pahayag ni na Senate Presiding Officer Enrile Soto at saka si Representative Pumali. Okay, mukhang hindi pwede. Anyway, Ivan, Vicky, birthday nitong si Senate Presiding Officer Juan Ponce Enrile at Valentine's din. Kaya sabi niya kanina, we will try to end daw at 5 o'clock para raw, sabi ni Enrile, ay makasama yung mga boyfriends at girlfriends ngayong Valentine's Day. Ivan, Vicky.
At si Vicky mukhang, kailangan din yata maaga ni Vicky. May date yata sila ni Attorney Renato.
Hindi, ito, ikaw ngayon nakadate ko at si Dean Pacifico Agabin. Tika, Joseph, kwentuhan mo naman ako. Ano bang nangyari kanina sa birthday ni Senator Juan Ponce Enrile? Di ba nagkaroon na parang salo-salo? No?
Meron dito, medyo sa same floor lang, may mga bisita siya. Ito sila Vice President Jojo Marbinay at saka itong si Armida Seguion Reyna at ilang mga senador din at ilang mga dating opisyal ng gobyerno. Ang sabi, tinanong si Senator Enrile, ano ba yung wish niya ngayong birthday niya? Ang sabi niya, gusto niya, happy tayo.
Tama, yun ang pinakamaganda, no? Tika, Joseph, ano ba, present ba parehong panig ng prosekusyon at depensa dun sa munting salusado ni JPE kanina?
Invited naman sila pareho at nakikita naman natin sila nagmi-mingle din sa bawat isa at wala pa naman tension this early. No? Pero tingnan natin mamaya kung ano yung magiging pangyayari sa loob ng Senate Impeachment Court.
Anong atmosphere kanina?
Sige, go ahead.
Maganda kasi dalawang okasyon to. Valentine's Day, so everybody's happy, everybody's in love. At saka birthday pa ng ating SP. So medyo maganda pa yung mood today. No? And usually naman, ang nangyayari lang ng mga tension ay sa loob. Pero pag sa labas yan, mga nagkakamaya, nagtatapi ka ng balikat, minsan nagkakantsawan. But overall, dun yung tension is mostly nakikita lang natin sa trial because that we can expect also talaga na intense naman yung mga debates yan about legal matters. Pero pag sa labas, friends. Parang sa media tayo. Pag coverage, talo-talo. Pero pagkatapos nun, uy, kita-kita bukas. Parang ganun lang.
Joseph, isa lang maliban sa prosecution, di ba pinagpapaliwanag din ang depensa why they should not be cited in contempt of the impeachment court tungkol doon sa press con nila nung Sunday?
Oo, pero I think ang pinagkaiba ay written, no?
Written,
yung hinihingi sa defense. Tapos yung sa prosec ay mas maikli at ang panahon, 24 hours. At ang sabi nitong si Senate Majority Floor Leader ay gagawin ito in open court. So mamaya, baka makita natin itong at least si Representative Neil Tupas na magpaliwanag tungkol doon sa circumstances kung paano nila nakuha yung mga bank records itong si Chief Justice Corona. Ivan.
Okay, maraming salamat, Joseph Morong. Babalikan ka namin maya-maya lamang.
Samantala, naging mahaba po ngunit mainit ang takbo ng paglilitis sa Day 16 kahapon at parehong nakatikim ng sermon mula sa korte ang prosekusyon at depensa. Matapos ang isinagawang caucus, nagdesisyon ang senator judges sa botong 13-10 na respetuhin at sundin ang inilabas na TRO ng Korte Suprema laban sa pagbukas sa dollar accounts ni Chief Justice Renato Corona.
Gayunman, hindi naiwasan ng ilang senator judges na magtalumpatit kundinahin ang isinagawang press con ng depensa nitong linggo, kung saan sinabi nilang may tangka o manong palasyo na suhulan ng tig 100 milyong piso ang sinumang senator judge na susuway sa TRO. Humingi ng tawad ang depensa pero hindi nila pinangalanan ng source ng kanilang isiniwalat na impormasyon.
Humarap na rin kahapon ang branch manager ng PS Bank Katipunan na si Annabel Chongson. Isinubuti niya ang opening balance ng 5 peso time deposit accounts ni Corona sa naturang branch.
Kalaunan, nasabon din ng impeachment court ang prosekusyon nang lumabas sa isinagawa nilang review sa CCTV videos sa Senado na wala ang sinasabi ni Representative Renato Umali na small lady na nag-abot daw sa kanya ng envelope taglay impormasyon sa umano'y bank accounts ni Corona. Lalo pa silang nadiin ang sabihin ni Chongson na peke ang photocopy ng dokumentong nakuha ng prosekusyon mula sa small lady na naging basehan ng kanilang hiling na ipasubpina mga naturang bank account ng punong mahistrado.
At habang hindi pa nagsisimula ang impeachment trial dyan sa Senado, siguro makakausap muna natin itong ating panauhin, si Dean Pacifico Agabin. Good afternoon po uli. Okay, ang unang tanong ko po, di ba, pinoint out kahapon ng branch manager nitong PS Bank Katipunan na peke sa kanyang paningin itong mga photocopy na ipinakita ng mga bank account ni Corona doon nga sa PS Bank. Kung anong magiging implication nito kung let's say ma-establish na peke talaga, does this mean mababasura ang lahat ng mga naging testimonya nitong mga PS Bank official?
Siyempre, Vicky, kasi kung peke ang dokumento, parang insulto na sa Senado yung pagsasubmitin ng pekeng dokumento. At yung mga abogado sa prosecution, dapat alam naman nila na hindi dapat mag-submit ng pekeng dokumento.
Alright.
Of course, ang initial issue dyan, kung talagang peke. Kasi malalaman lang naman na peke kung may kumpara doon sa original na nasa bangko. Pero ngayon hindi pa nakukumpara kung magkaiba o pareho
Pero mukhang na-establish na naman po kasi na, sige, even assuming peke yung dokumento, na-establish na naman po na existing yung mga accounts. Kahit po ba ganun existing yung mga accounts, basta peke yung dokumento, strike out yung lahat.
Tama.
Alright, so yan ang antabayanan natin. Titignan natin.
Ang gawin na lang nila ilabas yung original.
At yan ang inaasahan nilang gagawin ngayon. At samantala po, mga kapuso, nagsisimula na po ang impeachment proceedings. Panoorin po natin ito.
Lord, we are now on our 17th day in this impeachment trial. We pray that as a court, we have done justice to the expectations of our people and have been fair in the way we have dealt with the prosecution, the defense, and the witnesses who have thus far appeared before us. We beg you, O Lord, to enable us to use the impeachment process as a means of making our democratic practices more mature and of strengthening our judicial system. Also, dear God, please guide us through this impeachment trial so that love, not hate, fairness, not bias, justice, not injustice, and the truth, not falsehood, shall prevail in every session of this court up to the very end of our proceedings. Finally, dear God, we ask you to continue to bless our presiding officer, who is celebrating his birthday today, with the gifts of wisdom, patience, understanding, and good health. Please control his blood pressure so he can continue to ably lead and guide this impeachment court. All this we ask in the name of Jesus our Lord. Amen.
Amen. Thank you. Thank you for that Mr. Senator from Misamis Oriental, the Secretary will please call the roll of senators.
Honorable Senators Angara, Arroyo, Cayetano Alan Peter Compañero, Cayetano Pia, Defensor Santiago, Drilon, Ejercito Estrada, Escudero, Gingona, Honasan, Lacson, Lapid, Ligarda, Marcos, Osmeña, Pangilinan, Pimentel, Rector, Villas, Soto, Trillanes, Villar, the Senate President.
With 17 senator judges present, the presiding officer declares the presence of a quorum. Majority Floor Leader.
Mr. President, may I ask the Sergeant at Arms to make the proclamation?
The Sergeant at Arms will please make the proclamation.
All persons are commanded to keep silent under pain of penalty while the Senate is sitting in trial on the articles of impeachment against Chief Justice Renato C. Corona.
Majority Floor Leader.
Mr. President, I move that we dispense with the reading of the February 13, 2012 Journal of the Senate sitting as an impeachment court and consider the same as approved.
Is there any objection? There being none, the February 13, 2012 Journal of the Senate sitting as an impeachment court is hereby approved. The Secretary will now please call the case before the Senate sitting as an impeachment court.
Case number 002-2011 in the matter of impeachment trial of Honorable Chief Justice Renato C. Corona.
Appearances. Majority Floor Leader.
Appearances, may we ask the respective counsel to make their or enter their appearances, Mr. President.
Mr. President, for the prosecution, same appearances at pagpahintulot po ninyo na sa ngalan ng aming speaker at lahat ng kinatawan ng House of Representatives, kami po ay bumabati sa inyo ng maligayang kaarawan.
Maraming salamat po.
Ikan na kayo kumanya po, Diyos ti pigsa, regta, ken salun at Diyos.
Diyos ti ginaking ka, Apo.
For the defense.
For the defense.
For the defense, Your Honor, the same appearance.
Noted. Majority Floor Leader.
Mr. President, before the business for the day, may we recognize Senator Gregorio Honasan and then Senator Miriam Defensor Santiago for a manifestation.
Senator from Sorsogon, the Honorable Gregorio Honasan is recognized.
Thank you, Mr. President. Mr. President, I have only one question for clarification, which I would like to propound to both the prosecution and the defense counsels. Mr. President, distinguished colleagues, yesterday, the court, through some senator judges, called the attention of the prosecution and the defense to issues that are related to unverified information and allegations that impact on the impeachment trial. This unverified information we did not even bother to authenticate, but that is not anybody's fault. Mr. President, as we search for the truth and pursue our mandate to render justice, the court will continue to be confronted with these very same issues. Mr. President, some, many, if not all of us, have been victims of some form of injustice. We have always been on the receiving end, many of us. And during those times, we cried to high heavens when we were not even sure that somebody was listening. But apparently, somebody was listening because we are all here now. Now we have a court and senator judges who listen. They do not only listen, they move, they act. And again, we have an opportunity not only to do this right, but to do this well. In fact, Mr. President, nabanggit ko po yun dahil marami na tayong naririnig na komentaryo galing sa mga political analysts, mga students of history, na tayo raw po, komentaryo lang naman nila ito. We never miss an opportunity to miss an opportunity. In my attempt to gather my best lights, and as I prayed hard, I started reading the Constitution again, and I came upon the Bill of Rights. And I now call the attention of both the prosecution and defense to Section 2 of Article 3 of the Bill of Rights. Hindi ko memorize ito, kaya babasahin ko, pero I'm sure alam niyo ito. No? Section 2, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no search warrant or warrant of arrest shall issue, ito po ang gusto kong itanong, except upon probable cause, to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. Ang tanong ko lang po, and if it pleases the court, Mr. President, kahit na 2 to 3 minutes na paliwanag lamang, I'm not asking for a correct answer. I'm asking for an answer, so that I can incorporate this as we move inevitably towards that moment of judgment where we render a verdict. So I wanted to ask both the prosecution and the defense if this rule, this principle applies from where you sit to the impeachment trial proceedings, even if we look at this as a process that is political in nature. Mr. President, I have no follow-up questions, and I will take my leave and sit down and listen to a 2 to 3 minute explanation para maintindihan ko lamang ito.
Thank you.
Thank you, Mr. President.
Senator Onasan. I will start through by order of proof here in recognizing the parties to speak first, the prosecution.
Thank you, Mr. President. Unang-una po, ang usapin po dito ay hindi po tungkol sa search warrant o warrant of arrest. Ito po ay subpina na pinalabas ng hukuman ito dahil po sa relevant evidence na natanggap po namin tungkol po doon sa accounts ng nasasakdal po dito o yung respondente po. Kasi po, ang utos po sa amin ng kagalang-galang na Senado ay dapat liwanagin namin kung ano yung mga accounts na tinutukoy namin. At talaga naman po, masama naman po kasi yung mag-issue ng subpoena na nilalahat o general. Kailangan po specified. Kaya po, doon po sa aming pleading, patungkol po dito, yung request for issuance of subpoena, nakalagay po dito sa aming paragraph 10. At sinasabi po dito, kung itagalog ko po, kamailan lang nakatanggap kami ng anonymous source. An anonymous source provided the prosecution with photocopies of what appears to be PS Bank documents. These documents, copies attached as Annexes A to A-4 contain the following details. So, nilahad po dito kung ano po yun. Mga account number, date opened, lahat po na nakasaad po doon sa dokumento, linahad po namin dito. At tinatawag ko po ang pansin ng kagalang-galang na Senado dito sa 12th paragraph na ang sinabi po namin nung mga pumirma, yung aming Chief Prosecutor who is on the way po, papunta po dito dahil galing po sa House of Representatives. Nakalagay po dito, while it cannot vouch for the authenticity of the said documents, the prosecution believes that it is its duty to submit the documents to this honorable impeachment court, as they may have a bearing on the court's resolution of the pending request for subpoena. So maliwanag po na sinasabi po namin na hindi namin pinapatunayan na ito pong mga dokumento na ito ay talagang authentic kung ano man po, dahil para mapakita naman po yung good faith ng prosecution, simple po lang sana na inilahad na lang namin po yung numero ng mga accounts. Pero sa pag-akala na yung napasakamay sa amin, sa mga kasama namin, totoong dokumento po, linagay na po namin doon. kung kami po ay may alam na ito ay hindi totoong dokumento, talagang hindi naman po namin isasama doon dahil kami po ang mananagot doon. Kaya nilahad naman po namin dito na maliwanag na habang hindi namin pwedeng panindigan na itong mga dokumento ito ay totoo, ang pakiramdam namin ay obligasyon namin na paabot namin ito sa kagalang-galang na Senado para po sa paggabay sa pag-issue ng subpina. At dito nga po, nag-issue po yung kagalang-galang na Senado ng subpina ad testificandum at subpina duces tecum at hindi naman po inobject ng kabilang partido yon. At talagang grinant, ang question lang po yung tungkol sa dolyar na account at yun na nga po yung na-issue on TRO. Kaya wala pong usapin sa legalidad nung yung pag-issue ng kagalang-galang ng Senado ng subpoena duces tecum dahil sapat po at tama po yung basehan. Salamat po, Ginoong Pangulo.
Salamat. The defense?
If Your Honor, please, the gist of the question is whether this article applies in impeachment proceedings, Your Honor. My answer is yes, and definitely yes. This is part of the due process right of an accused or an impeached public official in connection with the charges leveled against him. Since the issue involved now is merely the propriety of a subpoena issued by this Honorable Court to compel the production of various documents, Your Honor, enumerated in the subpoena, it is akin or similar to a general warrant, Your Honor. And if it is akin to general warrant, then any and all proceedings in connection therewith must be considered against the right of the impeached public official to due process. Why do we say so, Your Honor? Because the right of an accused, in this case an impeached public official, is not merely limited to freedom from arrest, freedom from determination of probable cause, Your Honor, but also in cases that are akin to this kind of privilege or right, Your Honor. A general warrant does not specify the definite properties to be the subject of production or seizure, and therefore there is always a leeway for an abuse on the public officer exercising the right to enforce any obligation on the part of the respondent to an abuse of the authority, Your Honor. Here, for instance, and may we be allowed to quote the subpoena, Your Honor, it refers to various documents, current accounts, time deposits, certificates of deposit, settlement account, investment management, trust accounts, unit investment trust funds, mutual funds, or any and all financial instruments offered by the Bank of Philippine Islands, Ayala branch, in the name of the Chief Justice. If this is in the form of a warrant, Your Honor, there could be no question, and we feel that it is beyond contradiction that this will be a general warrant. Why? Because there are no specifications, Your Honor. They can immediately seize or ask the production of any of these documents, Your Honor. If that is so, then the right of the impeached public official to due process is violated. And if it is violated, therefore the entirety of the proceedings relative to the production of these documents must be against the constitutional right of the accused to due process, Your Honor. If the right of the impeached public official to due process is violated or infringed, Your Honor, then there is abundant jurisprudence to the effect that the entirety of the proceedings relative thereto is a nullity, and therefore, in order to save or to give impetus or enforcement to the right of an accused to due process, this must be circumscribed. The matter of subpoena, Your Honor, so must comply with the rules on search warrant, Your Honor. Must be specific, it must be determinative, and it must refer to a particular account, not merely a search warrant that can be utilized by a public officer in abusing the rights of an accused and in violation of his right to due process, Your Honor. That is our humble submission. Whether it applies, our answer is yes, because the Constitution is very clear, Your Honor. If there is a violation of this right, Your Honor, it says, any evidence obtained in violation of this or preceding section shall be inadmissible for any purpose in any proceeding, impeachment proceeding notwithstanding. That's our humble submission, Your Honor. Thank you.
Pwede po kami ng 1 minute na
thank you. I'll just the gentleman from Cavite.
Thank you, Mr. President. If I may add to the confusion, may mga jurisprudence. Sayang naman po kung hindi ko magagamit itong legal research ng aking staff. Tama po yon, inviolable sa under our Constitution yung pagiging secure ng mga tao, mga private citizens. Pero may mga jurisprudence po na nakalahad dito. Ang sinasabi po rito, kung walang intervention ng Estado at isang pribadong individual, I will start my short manifestation and end it with a question. Dahil po medyo na-confuse din po ako dahil magkabilang panig, magkaiba yung position, pareho ko yung magagaling na abogado.
Salamat po.
Ang sinasabi po rito sa People versus Andre Marti, no? GR number 81561, January 18, 1991. Minention pa rito yung 4th Amendment ng Estados Unidos. At hinalimbawa yung isang security guard or parking attendant na illegally sinerch na yung kotse na nakapark sa kanyang binabantayan na area at nakakita siya ng marijuana. Nung ito'y dinala sa korte, ang sinabi ng korte, admissible ito dahil walang intervention ng Estado at walang tulong ang poder ng gobyerno na pamahalaan. So ito po'y pinayagan. Ang tanong ko po dito sa issue at hand, may tuturing ba nating itong ating mga public prosecutors na mga congressmen, ito ba'y may tuturing natin na mga ginawa na nila ito bilang pribadong individual o sila'y gumamit ng power, ng poder ng Estado o bali sa kanilang pagiging congressmen, mga kongresista, sila ba'y natulungan ng otoridad ng ating pamahalaan? Yun lang po ang aking tanong para maliwanagan ng aking isip. Pero hindi po absolute yung sa inyo pong dalawa. Alam ko pong hindi absolute yung sinasabing inviolable yung pagiging secure ng isang mamamayan laban sa mga illegal searches and seizures. Dahil alam naman natin pagka plain view, halimbawa po, at pagtapos ito'y search of a motor vehicle at yung customs enforcement, hindi po nasusunod yung warrants or search warrants. So yun lang po ang gusto ko maliwanagan bilang non-lawyer dahil sa aking pagbabasa rin mukhang may konting confusion. Salamat po.
Kung gusto ng mga abogado ng magkabilang panig na sagutin yung tanong ng ating kagalang-galang na senador ng Cavite, Senator Pamphilo Lacson, ay open ang hukuman na ito na dinigin ang sagot ng magkabilang panig.
If we will be given the opportunity, Your Honor, we will do so.
Kung ipagpahintulot po ninyo, Ginoong Pangulo.
Ang prosecution.
Opo, doon po sa sinabi ni kagalang-galang Senador Lacson, conforme po kami doon, yung mga warrantless searches po yon. Pero dito po ay nag-issue po mismo ang Senado ng subpina. So maliwanag po ito, nakapangyarihan ng Senado ang mag-issue ng subpina. At nung in-issue po yung subpina, very particular po, hindi po general subpina ito dahil pirmado po ng Ginoong Pangulo po ito. Subpina ad testificandum ad duces tecum dated February 6. Napakaliwanag po dito. Sabi po dito, to bring with you the original and certified true copies of the opening documents for the following bank accounts, numbers 1, 2, 3, 4, 10 accounts po, in the name of Renato C. Corona, and the bank statements showing the year-end balances for the said accounts as of December 31, 2007, 2008, 2009, 2010. Ang pinagbabawal po ay yung, sabi po nga ni Justice Cuevas, yung pangkalahatan po na warrant na kung ano-ano na lang ang padadala mo dyan at bahala ka nang magkalap doon o ano. Dito po napaka-specified po napakaliwanag po. Kaya it conforms with the constitutional mandate that the warrant or the search warrant should describe with particularity. Ang liwanag po. Napakaliwanag po. At isa pa po, nung na-issue po itong warrant, meron naman pong remedyo yung kabila na pinakwas sana ito kung mali yung subpina po. Kung talagang ang sa tingin nila, labag ito, sasaligang batas, dapat pinakwas po nila yung subpina. Hindi po tumahimik po sila. At sa katotohanan po, krinos-examine pa nila yung witness, pati yung mga dokumento. Nandito po sila. At ang ating jurisprudence po, yung pagkakamali ng abogado, talagang the client is bound by the mistake or lapses. Papatawad po ninyo. Kasi po, hindi naman po nila in-object. Pwede naman po nilang pakwas. Katulad po yung isang subpina po namin ngayon. Ino-object po nila, kaya hanggang ngayon, hindi pa po natin nadidesisyonan. Pero ito po talagang inisyu ng Senate President, wala pong umangal sa mga miyembro, wala rin pong umangal sa mga partido, at sa katunayan po, lahat po ng tinawag na mga dokumento dito, napasok na po, namarkahan na po namin, kaya sa tingin po namin, nandun po, hindi lang po presumption of regularity, nung pagka-issue ng kagalang-galang na Senado, kundi tumalima na rin po yung kabilang partido dito po sa subpinang ito.
Ang depensa?
If Your Honor, please, I'm sorry to dissent from the opinion of and comment made by the Honorable Counsel for the prosecution, Your Honor, because we have on record, Your Honor, a consolidated opposition and rejoinder, which we filed February 6th, and we have a copy thereof, questioning the legality of the issuance of the subpoena which had been issued by this Honorable Court. Now, the subpoena in question now, Your Honor, is the subpoena requiring the appearance and production of the various documents mentioned in here, which appearance and production must be made at 2 o'clock in the afternoon on the 14th day of February 2012. We did not have the opportunity even to object, Your Honor, much less a motion to quash. We are preparing it, and with the kind indulgence of this Honorable Court, we will be filing it today, Your Honor. So, time constraint forbids us from immediately acting on this motion, Your Honor. Now, we do not question, I hope we will not be misunderstood, Your Honor. We do not question the authority of this impeachment body, Your Honor, to issue the subpoena prayed for, Your Honor. But since this is ducis tecum, not only testificandum, there must be a showing of the materiality, relevancy of the documents sought to be produced, and that otherwise it will be considered as oppressive and to the detriment of the impeached public officer, because it is a violation of his right to due process, Your Honor. Why do we say so? A mere examination of the subpoena in question, Your Honor, will sustain or lend credibility to our postulation, Your Honor. It mentioned any and all peso savings account, current accounts, time deposit, certificate of deposit, settlement accounts, investment fund, management and trust fund, unit investment trust fund, mutual funds, and any and all other financial instruments. Is that not convincing enough to show that this is equivalent to a general search warrant, Your Honor? What, for instance, are the materiality of this document? What are they in the first place? Will they be relevant or material to the issues involved? The way we understood this, Your Honor, as we go along trial of this impeachment case, this is merely in support or in connection with paragraph 2.2 and 2.3, and never on the issue of ill-gotten wealth provided for and spoken under 2.4, Your Honor, because there is already a resolution of this Honorable Court that the prosecution is debarred or prevented or hindered from presenting evidence towards that end. That ruling had never been modified, much less revoked or withdrawn by this Honorable Court. It is along those lines that we submit, Your Honor, that this is practically the equivalent of a general search warrant, giving all the leeway and paving the way for grave abuse of discretion on the part of the party serving the subpoena to compel the production of this document. If this is served upon member, for instance, of the prosecution, what documents will they present? What year and so on? And what is the purpose, Your Honor? Because it is not enough that there is a subpoena. That is beyond dispute, Your Honor. We never question the right and authority of this impeachment court to issue the subpoena. It has the power to. But in the exercise of that power, it must be within the prerogatives, within the ambit of our constitutional provision, Your Honor. That had been succinctly declared, and it had been indelibly discussed in the case of Francisco et al. Versus the Honorable Court of Appeals. We submit, Your Honor. Thank you very much.
Mr. President.
The gentleman from Taguig, the minority floor leader.
Mr. President, magandang hapon. Being a very special day, the day of love and hearts, and being the natal day of our good Senate President, I'll try not to argue with anyone.
Happy Valentine to you.
Happy Valentine, and
to everybody.
It's our pleasure to share your birthday with you today, sir.
Birthday of no birthday, we work for
Thank
the
you,
country.
So I'll try not to argue with people today. Defense Counsel, sir, Justice Cuevas, you may want to answer through the memo that you're going to submit, or through a memorandum, or if you'd like to expound, depending on the time of the court, no?
Yeah,
pero I thank you for bringing up this issue, and tingin ko po dapat talaga himayin yung thin line, kung meron man kung thin man o makapal ang line between the rules of a search warrant and a subpoena. Pero lang para sa paglilinaw po sa akin, pag binasa ko po yung mga memo nyo ng prosecution at ng defense. Number one, ang pagkaintindi ko po sa search warrant ay utos ng korte because may probable cause, no? Ibig sabihin, hindi to fishing expedition. Kung hindi dahil may probable cause, meron na numpa dun po sa huwes na nagsasabing may mahahanap sa isang lugar, so meron search na mangyayari. So halimbawa sa isang bahay, dokumento man, drugs man, counterfeit na pera, hindi pwedeng basta't dadating doon at halukayin yung buong bahay. Kailangan may probable cause, kailangan specific yung warrant, anong bahay, saan bahay, pero hindi kailangan specific na isang kwarto lang. Pwedeng yung buong bahay, halimbawa, ang hahanapan nung droga, halimbawa. Ang subpoena naman po, ang pagkaintindi ko, ito'y utos ng korte na number one, mag-testify ang isang tao, or number two, magdala ng dokumento. So going back, ang rule sa search, no? Pag unreasonable yung search or arbitrary o sinasabing fishing expedition yon, or illegally obtained, no? Ibig sabihin walang search warrant at hindi nagfo-fall sa mga exception na sinabi ni Senator Lacson, ay ang pumapasok na batas doon yung fruit of the poisonous tree, o sinasabing lahat ng makuha mo doon hindi pwedeng gamitin. Hindi pwedeng tanggapin ng korte kahit 1 tonelada ng shabu ang nasa harap natin ngayon at aminado na sa kanya galing. Pero kung masasabing illegal ang search, hindi pwedeng gamitin yung ebidensya na yon. Until that point, we agree. But until the point of the subpoena, when you issue a subpoena, you're merely requiring someone to produce something. We did not require the bank to bring any, we did not subpoena the BSP and say any bank account of Justice Corona. There was certain bank account numbers given by this court. Number two, while the doctrine of the poisonous, the fruit of the poisonous fruit is clear, and all lawyers will know that when it comes to illegal searches, sa subpoena po, ang lumalabas po, di ba, pag may exclusionary rule, ibig sabihin nakalagay sa batas na yon, any evidence obtained through this cannot be used in court, de malinaw na hindi pwedeng gamitin. Pero pag walang exclusionary rule, ibig sabihin, pwede pa rin gamitin. Halimbawa po, or at least question mark, and I'll allow you to explain if your view is that even without an exclusionary rule, pwedeng gamitin. Halimbawa po sa bank accounts, no? Ang nakalagay doon, paparusahan lang ang taga-bangko na naglabas nun. Pero walang nakalagay doon sa batas na yun na hindi pwedeng gamitin. Kaya yung testimony ni Clarissa Ocampo ay ginamit. Or to use a more example na mas alam ng ating kababayan, si Senator Lacson po, nung lumapit sa kanya si Mr. Udong Mahusay, may dala ho siyang bulto ng dokumento, may mga bank accounts allegedly ni First Gentleman at ni Jose Pidal. No? Kung ano-ano nakalagay doon, Morgan Stanley, sa mga bangko, may mga iba pang hindi nilabas si Senator Lacson dahil tingin niya compromising yon. Yung po, theoretically, ay nakaw ni Udong allegedly kay First Gentleman. Bakit? Hindi naman sa kanya yon. Pero hindi siya illegal search dahil hindi naman gobyerno at hindi naman po mga taga-NBI o police ang kumuha. So, yung po ba ay, I'm not asking this specific case, no, but just so that we can understand and I can understand. Ang pagkaintindi ko po, walang exclusionary rule yun. May violation of the bank secrecy law dahil yung isang katiwala ni First Gentleman ay naglabas ng dokumento na hindi sa kanya at ninakaw niya yon. Pero hindi naman illegal search. Hindi naman chief PNP si Senator Lacson nung panahon na yon at lumapit sa kanya. So, sir, when you make the memo of law, I get what you're driving at. But can you help us by showing us that fine line? When is a subpoena legitimate? And when do you think a subpoena will now become illegal or unreasonable search, giving us the logical conclusion that it will fall under the doctrine of the fruit of the poisonous tree? Or where is a subpoena either legitimate or when is a subpoena defective but it does not affect the admissibility of the evidence? As to relevance and materiality, I hear where you're coming from. Ibang issue yon. I'm just talking about the exclusionary rule, the rule of whether evidence can be accepted or not. So I think this is something that both parties have to clarify on that issue. Saan po ang thin line at saan po nagkakaiba ang subpoena at ang search warrant po or ang unreasonable search? Thank you, Mr. President.
Mr. President.
There being a request from a member of the court for the submission of memorandum to clarify this issue. It is the mind of this presiding officer to request both parties to submit the respective memorandum on this specific issue, not only for the information of the public, but for the guidance of this court as well. And this presiding officer will make a statement after everybody has spoken.
If Your Honor, please, very willingly we will comply, Your Honor.
May I just let the defense counsel first to finish?
Very willingly, Your Honor, we will comply. But may we request that we be given at least 5 days, Your Honor, in view of the importance of the issue involved, Your Honor.
Granted.
Thank you, Your Honor.
Granted.
May we ask for the same period as well, Mr. President?
Granted.
Mr.
Thank
President.
you, sir.
The gentleman from Pampanga.
Yes, on the issue of the memorandum, if you may also consider explaining to this court why you would consider subpoena or a subpoena of this court in the same category as a warrant of arrest or a search warrant. Please.
Yeah,
so that
definitely we will.
Thank you.
Definitely we will.
Yes, sir.
Mr. President, may we recognize Miriam Defensor Santiago on another issue.
This is a legal manifestation addressed to both panels. Gentlemen, you
The
may
gentle lady from Iloilo is recognized.
Thank you. Gentlemen, you may take your seats. In the first place, I don't understand why we are discussing a search warrant. This court has not issued a search warrant. What search warrant are we talking about? What we issued was a subpoena. Therefore, the issue should be, what are the effects of the subpoena, considering that when the subpoena was requested for by prosecution, it attached what purported to be bank documents, but immediately the prosecution disavowed any knowledge of the authenticity of the document. Therefore, the issue is, can counsel in any proceeding attach to his request for subpoena a document about which he knows nothing? That's the issue. Hindi mo pala alam kung ano yun eh. Bakit mo sisingilin kami na issue kami ng subpoena? Ano yun? That's only a scrap of paper. Why are you doing this to the court? Why didn't you go hit your law books? So, kung ano mga pinagsasabi nyo Hindi naman ito kursunada eh. Siguro ito sa jurisprudence. Dito sa inyong supplemental request for subpoena /reply dated February 3, paragraph 11. I will start even earlier. Paragraph 10. Recently, an anonymous source provided the prosecution with photocopies of what appears to be PS Bank documents without more. Pwede na ba yon sa korte? An anonymous source told us. So we're alleging it in our request for subpoena. Is that allowed? Can you allege something in open court or even in a written pleading with a court that you have information, but it is based on an anonymous source? My goodness, if you bring this to any trial judge in the entire country, particularly in Metro Manila, you'll be cited for contempt. I know that I said that impeachment is quasi-judicial and quasi-political, but you cannot tamper with the rules of court which are suppletorily applicable to our rules of the Senate on impeachment. Saan ka nakakita ng pleading na somebody anonymous said like this to us, so we're going to ask the court to do something? What kind of respect for the Supreme Court are you entertaining in your minds? Pangalawa, basahin ko sa inyo, this is a very, very strange, bizarre document. Imagine telling me if I were a trial judge, an anonymous source told me, Your Honor, that something happened, so will you please issue a subpoena? Can that be a basis for issuance of subpoena? Paragraph 11. Moreover, it seems that the media itself also sources information. Kailan naman ng judge pwede mong hikayatin o pwede mong pakiusapan na gumawa ng kung anong mga aksyon na gusto mo, issuance of a subpoena, on the basis of a media account? My goodness! Is this government by media or is this judicial system by media? Again, this is a ground for contempt. If I were a trial judge, I would say, you're wasting my time. Sheriff, take him to city jail. Direct contempt yun eh. Pero mo, if you're going to the court in a serious frame of mind, you are met by this kind of a pleading. May narinig kami sa isang babae na hindi namin masabi kung sino yon. May nabasa kami sa dyaryo. Opposing counsel in all trial courts of our country will go apoplectic objecting to that kind of a request. May just point that out to those people who have never been to trial court. Paragraph 12. While it cannot vouch for the authenticity of the said documents, the prosecution believed that it is its duty to submit the documents to this court as they may have a bearing on the court's resolution of the pending request for subpoena. Huh? Say again? 1, I heard someone who I cannot identify say something. Number 2, I read it in the media. Now, it is my duty to bring it to the attention of the court. Duty my foot. It is not your duty. It is your liability. That is disgrace to the judicial system. And I have basis for saying that. I will read you the case. In these cases of false or fake documents, which yesterday the bank manager asseverated, she said, that's a fake document. In the case of fake documents introduced in court, here is what the Supreme Court had to say. Based on administrative cases against certain judges, an administrative case is a case for disbarment. Ganon katindi. Pag nagbigay ka ng peke dokumento, peke na testimonya sa korte, ganon katindi yan. Pwede yung base na ipadisbar mong abogado. There are 2 cases. One, where the lawyer himself did not know that the document was false, did not participate in its preparation. And the other is where the lawyer willfully introduced what he knew to be fake documents. Let's talk about the first instance. The lawyer willfully knew the document was fake. Here is what the Supreme Court said in Samala v. Valencia. I beg the indulgence of this court. I'm hyperventilating because I'm very, very upset. I will leave this court immediately because I'm sure I have hypertension. Samala v. Valencia, 512 Scra. 1, decided in 2007. Here is what the Supreme Court said. Respondent cannot feign ignorance of the fact that the title he submitted was already cancelled. In other words, the Supreme Court is saying, we are concerned, we are aghast that the lawyer knew that the document he submitted was false. Respondent failed to comply with Canon 10 of the Code of Professional Responsibility, which provides that a lawyer shall not do any falsehood, nor consent to the doing of any in court, nor shall he mislead or allow the court to be misled by any artifice. It matters not that the trial court was not misled by respondent's submission. Notice the court said, even if that false document did not mislead the court, still the lawyer is liable. Because the burden should not be placed on the court to determine whether the document is true or not. It is the duty of the lawyer who is introducing it. It matters not that the trial court was not misled by respondent's submission. What is decisive in this case is respondent's intent in trying to mislead the court by presenting this document. That's what the Supreme Court said. If the lawyer willfully introduced fake document, the Supreme Court will condemn the lawyer. I will see what the penalty was. Accordingly, the court finds the lawyer guilty of misconduct and violation of Canons 21, 10, and 1 of the Code of Professional Responsibility. He is suspended from the practice of law for 3 years, effective immediately upon receipt of this resolution. That is a decided case. It binds us all here. But that is in the case of a lawyer who knowingly and willfully introduced a fake document. Now let us grant the presumption of innocence to the prosecution panel. Suppose they did not know, as they indeed said in their pleading, they could not vouch for the authenticity of the document. Do they still have any liability? Yes, said no other than former Chief Justice Enrique Fernando, one of the most brilliant lawyers produced by this country. Justice Fernando wrote, in the case of Berenguer v. Carranza, 26 CRA, CRA 673, promulgated in 1969. The lawyer had, in the preparation of the fake document, the lawyer had nothing to do with it. And therefore, the charge of deliberate deception obviously cannot be sustained. But, the court went on, would that of itself entirely exculpate him from any responsibility? The answer must be in the negative. Maski hindi mo sinadya, maski hindi mo naintindihan na peke pala yon, pag na-introduce mo yan evidence at natuklasan na peke pala, ay may pananugutan ka pa rin pala. As was correctly pointed out in the complaint, his failure to exercise greater care did result in the confusion and prolongation of the suit. Kasi nalilito kami eh. Under the circumstances, it would be to err on the side of undue leniency if he would be held blameless. He had incurred liability. His fidelity to his oath as attorney was less than entire. Every member of the bar must be on his guard, lest through oversight or inadvertence, the way he conducts his case or the evidence he presents could conceivably result in a failure of justice. Even if there be no intent to deceive, therefore, a lawyer whose conduct, as in this case, betrays inattention or carelessness should not be allowed to free himself from a charge thereafter instituted against him by the mere plea that his conduct was not willful and that he has not consented to the doing of the falsity. The Supreme Court found him guilty and issued a penalty of reprimand with a warning that repetition of the offense will be more severely left with. This is the ruling of the Supreme Court. Pinalitan na ba natin itong mga ruling na ito? Pwede na pala ngayon, maski media ka, pwede mo nang i-narrate sa korte na hindi mo naintindihan kung tama yun o totoo yun o binigay yan ng PR, ng Dirty Tricks Department na kung sinong PR firm. Come on! Wake up! We all know how politics is done in this country. Just because you admit that this is a quasi-political proceeding does not mean that we can turn this into completely political circus. Kaya, I submit to my colleagues, I respectfully submit to these colleagues, my colleagues, what is the role of media while this trial is pending, while this trial is sub judice? Pababayaan na lang na ba sila na magbibigay ng kung anong lead dyan na identify tayo isa-isa. Itong mga senador na ito, pro-Aquino ito. Ito naman, pro-Corona. What does it say of our integrity? Pababayaan lang ba sila? Libreng-libre ba sila in the name of freedom of the press? I think we should think very carefully about the sub judice ruling. While a case is pending in court, there is a gag rule. No person may orally or through other means, by media, for example, comment on the merits of the case. Even we are not allowed to do that. Shall we allow media to do that? Nilista tayo isa-isa, dito kaliwa, dito sa kanan. May kaso dito Ay di kung ganun pala, if this is going to be trial by publicity, let us invoke the Constitution and ask for a change of venue. Perhaps out of the country. We all know that the Constitution itself recognizes that public opinion can be so prejudicial in a pending trial that under the Constitution, the Supreme Court may order a change of venue. Ganon katindi ang ayaw ng korte ng is public opinion that will teach lawyers who have trained for 9 years to become lawyers on what the law is or how it should be applied by people who have never applied the law in trial court. Kung ganito ito, huwag na tayo magbasa pa. That is all, Your Honor. Thank you.
Thank you. Now, may I now state the position of this humble presiding officer, and this position is subject to the opinion of the court, of the Senate sitting as an impeachment court. The Senate, it is by the humble view of the presiding officer that the Senate as an impeachment court must at all times observe the rule of law. It cannot transgress any of the applicable provisions of the Bill of Rights. It must be guided by the presumption of innocence before the pronouncement of guilt. It must at all times observe the principle of procedural and substantial due process. It cannot use its power to issue compulsory processes to compel any witness to appear and testify, and in testifying is forced to commit a crime. It cannot compel a witness to testify against himself. It cannot arbitrarily declare a person guilty of contempt and deprive that person of his or her liberty. It cannot violate the laws passed by Congress, of which it is an integral part. That is the humble position of this presiding officer of this Senate sitting as an impeachment court. Now, as far as the subpoena duces tecum involved, which was issued by this presiding officer upon the behest of the prosecution, this presiding officer assumes full responsibility for issuing that subpoena and is ready to defend his position in any court of law if there is a need for that. I will not pass the buck to the Senate sitting as an impeachment court. It was my decision as a presiding officer, and I am personally bound to assume the consequences of my action as a presiding officer. Having said that, I do not wish to delve on the issue of whether the exercise of the power to issue compulsory processes by this court in this particular instance involving Republics Act 1405 and Republic and 6426. I do not want to make any pronouncement on that because precisely this court, through this presiding officer, exercise the discretion to heed the request of the prosecution to issue a subpoena duces tecum to help them obtain the evidence they wanted in the face of proscriptions by laws of the land passed by Congress. And that is the subject matter now of the case before the Supreme Court, filed by a private party asserting its rights under the law of this country and under the Constitution to be protected from any liability. And that is the reason for which the Supreme Court issued a TRO. And that was also the reason why this court, or a majority of this court, yesterday ruled in an open and influenced voting that this court must respect the order of the Supreme Court to issue its temporary restraining order. Whether or not, in the end, this court abused its discretion or committed a grave abuse of discretion amounting to lack or excess of jurisdiction will be decided or has to be decided by the Supreme Court, being the highest court of the land and the final arbiter and interpreter of the Constitution of this country. For no one else was given by the sovereign people in their Constitution the power to make a final determination or interpretation of what the Constitution ought to be or what a law ought to be, except the Supreme Court. Not the executive, not Congress, but only the Supreme Court. And so it is my bounden duty as a presiding officer of this impeachment court to respect the authority, the power of the Supreme Court to review acts of this impeachment court in interlocutory matters, meaning matters bearing on the manner by which this court would conduct the trial of this particular impeachment case. But it is my humble view that the Supreme Court, in spite of the fact that it has the power of judicial review, cannot assume jurisdiction over the power, the sole power of this Senate, sitting as an impeachment court to try and decide this impeachment case. That is the position of the humble presiding officer. The gentleman from Iloilo.
We do not wish to debate on this point, just to register that we have a different view of the matter of the Supreme Court having jurisdiction over interlocutory orders of this court. We just want to register that position on record, and we do not wish to argue that point, but just so to preserve our position on that point, Mr. Chairman. Thank you very much.
Mr.
President.
Anyone else? Majority Floor Leader.
Mr. President, may we now call on the prosecution for the continuation of the presentation of evidence.
Mr. President, may we make a manifestation po, Ginoong Pangulo, tungkol sa mga witnesses po natin dahil yung testigo po na manager ng BPI, ang pakiramdam po niya, baka manganak na siya. Kung pwede, unahin na daw po siya. Ready po raw siya kung...
Nasa sa inyo po kung sino ang gusto ninyong unang uupo na testigo ninyo.
Thank you, Mr. President.
Hindi kinokontrol ng hukuman na ito ang order of presentation ng mga ebidensya ng magkabilang panig dito. Nasa inyo yan.
Salamat po, Ginoong Pangulo.
If Your Honor, please.
The Defense Counsel.
If the witness referred to, Your Honor, is Madam Chongson.
No. Mrs. Dizon of Bank of the Philippine Islands.
The records will show that the direct examination, together with the cross-examination, had already been terminated. So I do not see how she can be called again for further questioning, Your Honor, either by the prosecution or by the defense. That will be violative of the rules of procedure, Your Honor. Once the testimony of the witness has been terminated by the termination of the direct and cross-examination, he may not be recalled, or she or may not be recalled without the permission of the court and for good caution, Your Honor.
Let the prosecution perform their job, make the proper, follow the procedures in the recall of witnesses.
Ang pagkasabi po ng aking hepe dito po ay siya po daw ay tinawag ng kagalang-galang na Senado po na magdala ng mga ibang dokumento yata na kailangan po ng kagalang-galang na Senado po. Kaya po...
Hindi. Ang tanong, ang testigo po ninyo kung sino ang pauupuin ninyo sa upuan ng testigo.
Tinatawag po namin si Mrs. Dizon, manager po ng Bank of the Philippine Islands, Ayala Branch.
Pero ang sabi ng depensa ay pinaupo na ninyo yung testigo na yan at natapos na ninyo ang kanyang direct examination.
We have even...
May I ask that the Attorney Art Lim, one of the private prosecutors, be recognized, Mr. President?
That will be violative of the rule on supervision and control by the private prosecutor by the representative of the House of Representatives, Your Honor.
Hindi po, because he will appear under our direction and control, but it was him who was handling the witness, so I do not know the finer points as to where we stop, as to what the precise stage of the proceedings are we in, Mr. President.
So if Your Honor, please, it is now the public prosecutor under the control and supervision of the private prosecutor.
Not at all, Mr. President.
That is decidedly...
In fact,
the situation is this. Let me clarify. It is true that the prosecution has control over their panel. Precisely, they're asking now the court to allow their private counsel to take the podium to explain. And that is in exercise of the power of control of the panel of prosecutors designated by the House of Representatives. So I will permit it.
Thank you, Mr. President.
Mr. President, over here. Mr.
The
President.
gentleman from Sorsogon.
Point of information, Mr. President, and I hope the records will bear me out. I think indeed both direct and cross were finished in a previous hearing, only that some senator judges had questions of this witness. And in fact, I think one of our colleagues asked for a subpoena so that the witness can produce some documents. If my recollection serves me right, it was Senator Osmeña who had some queries of this witness. So, Mr. President, I think that's the stage where we are in right now. The witness was recalled so that a senator judge can propound questions with respect to additional documents he requested, and not for either of the parties to propound additional questions on direct or on cross.
Correct. That's correct. That's why this representation caused the issuance of a subpoena, because a member of this court wanted the witness to be recalled because he wanted to ask further question by way of clarification.
Yes, Mr. President.
The gentleman from Iloilo.
That the statement of Senator Escudero and the presiding officer are confirmed by page 64 of the Journal of the Impeachment Trial, Journal number 16, dated Thursday, February 9, 2012. Additionally, Your Honor, in addition to what Senator Escudero and Your Honor mentioned, this representation, if you recall, also was interested in looking at the monthly statements which counsel for the defense voluntarily said will be available for examination. And again, that is found in pages 64 and 65. In fact, if I may quote the presiding officer, it says, in the case of this particular account that we are now discussing, in effect, the depositor already gave permission for the examination of all accounts month by month from the beginning of the opening of this account up to the year ending December 31, 2010.
That's also the recollection of the presiding officer.
So really this witness can be recalled to testify on these two items. Your Honor, I'm just confirming that.
Then the witness is ordered to enter the plenary session, take the witness stand, and testify under the same oath. Proceed.
May it please the Honorable Court, Attorney Lim as private prosecutor under the control of the public prosecutor.
Are you going to make a redirect?
Your Honor, this will be additional direct because
no, I will not allow it. I will allow the member of this court that requested for a subpoena to direct questions to this witness.
We submit, Your Honor.
All right. So, the gentleman from Iloilo may now proceed to ask questions from the witness.
Thank you, Mr. President. Madam Witness, the Senate President during the last hearing asked you to produce the monthly statements of the peso account of the Chief Justice Corona from 2005 up to 2010. It will be recalled that counsel for the respondent, the Chief Justice Corona, manifested before this court that he was willing to go to the offices of your bank and examine these documents. And it is at this point that we ask that this court be allowed to share and be notified and be informed of this document. Do you have these documents with you?
If Your Honor, please, if I intervene, Your Honor, and object, I will be ruled out of order.
Yes, what is the pleasure?
So I just want to make a manifestation, Your Honor.
Go ahead.
There was no statement made by us that we are willing to reveal all these things, Your Honor. We were asking for the breakdown of that deposit because we feel that this being a current account, there are monthly statements, Your Honor. And the reason for that is we have not conferred, in so far as this matter is concerned, with Chief Justice Corona. But after he assured us that we have these documents with us, we find no necessity to go over the documents in possession of the bank, Your Honor. In fact, we have filed a manifestation, which we filed on February 13, Your Honor.
Correct. That is my also the understanding of this chair, that we were talking about this specific bank account and the monthly bank reports for the depositor from 2005, I think,
yes,
it was, all the way to 2010.
That's correct.
And only the running balance of this account. If you remember, we were talking about an ending balance as of 2010 of 12 million pesos, I think, if I remember correctly.
14 million something, Your Honor.
Anyway, whatever it is. And then I said, this is a current account, and it was opened in 1989, and I asked whether the ending balance, whatever it was, whatever that amount was, whether it was 12 million or 14 million, is a sum total of all the transactions, deposits, and withdrawals over that long period of time. And I was corrected by the counsel for the defense when he said that only from 2005 up to 2010.
That's correct, Your Honor.
So that is the situation.
Yes, Your Honor.
It did not call for any other documents outside of those monthly balances for the operation of that current account.
Yes, Your Honor.
Okay.
This was brought about by our cross-examination, Your Honor, and it was what we were trying to clarify is what makes up the alleged 14 million deposit, whether it was one single transaction or various transactions. And in considering that up to that time there was no assurance on the part of the Chief Justice that we have the necessary documents with us, we made the request. But finding out that we have the necessary documents, Your Honor, to explain or further this amount of 14 million, Your Honor, we have chosen to withdraw. And we cannot be compelled by I'm sorry, Your Honor. And we cannot be compelled by the prosecution, much less by a single senator judge to do whatever is not in accordance with our postulation or articulation, Your Honor.
By the way, this is started when the defense counsel agreed about the submission of the monthly statements for this particular current account of the respondent. And I even suggested that both the prosecution and the defense ought to go to the bank themselves to expedite the proceeding to look at those bank accounts. But later on, the defense counsel said they have some of the records in the possession of the depositor, and who is actually the respondent in this case. And that is where some discussion again ensued. That is the recollection of the chair.
That's correct, Your Honor.
Your Honor, please.
But
Your Honor.
may I be able to read into the record, Your Honor? what precipitated that particular issue by way of discussing the same, Your Honor. I am referring to the minutes of the proceedings of Thursday, February 9, 2012, Your Honor, transcript. This is, presiding officer, this is a simple problem. Let them decide who is going to confer with the very able defense counsel. So you want to deal with the head of the panel. I think since they have control over their panel and their defense counsel, they can designate whoever they want to go with the defense counsel to examine the records. Mr. Cuevas, this is my point, Your Honor. Your Honor, please. Presiding officer, yes, Justice Cuevas. While the court is debating among its members the matter of inspection or production of the statement of accounts, Your Honor, my co-counsel in the defense received a call from Chief Justice that he has these documents, Your Honor. Some of these documents I'm referring to, the statement of accounts, are with him. I would not know which will be material to us. If this is true, then in effect we are withdrawing the motion because we have them already with us. That is my point, Your Honor. We will not unduly burden our colleagues, Your Honor. That is the end of the discussion, Your Honor. We cannot be dictated upon. I beg permission of the court, Your Honor, by stating this on record, on how we should handle the defense for our client. That is our sole responsibility to our client, Your Honor. Neither the prosecution can tell us what to do because we are not under the control or supervision of the prosecution.
Your Honor, please, may the prosecution...
Let the defense speak first.
Sorry,
I'm not bright enough to have all of you talking at the same time.
My apologies, Your Honor.
Then the presiding officer, then why can you not talk to your client and then communicate with Mr. Cuevas? We will do that, Your Honor. Precisely that is why we are asking up to Monday, Your Honor. Presiding officer, let it be Monday. Thank you, Your Honor. That was the end of the discussion insofar as the statement of accounts are concerned. Why will be compelled to go to the bank and examine this when we have the documents that we wanted to present, Your Honor?
Right. Are you true?
Yes, Your Honor.
All
Thank
right.
you very much for the opportunity.
Prosecution.
Thank you very much, Your Honor. My apologies once again for the...
No, don't apologize anymore. No more pasicalles. But just go direct to the point.
Your Honor, with due respect to the defense counsel, what he has stated are not in accordance with the record. The record of February 9, 2012 will bear out that there are now 3 sets of documents. The first set of documents were those required to be produced in the subpoena of February 6, 2012, which this humble representation elicited from the witness. And after completing the testimony, indeed, I confirm now that I stated that is all for the direct, and Justice Cuevas started on his cross. Unfortunately for the defense, during their cross-examination, they themselves went into the matter of monthly statements, which were not in the subpoena. But motu proprio of their own volition, they went into monthly statements.
That's correct.
Yes, Your Honor. And then, there was that agreement initially for both sides to go to the bank when I withdrew my opposition that he will go there by his lonesome. And then the Honorable Presiding Officer was judicious enough to suggest why don't the two sides go together.
Up to that point, correct.
Yes, Your Honor. And so, there was that subsequent manifestation by the defense counsel that, after all, they were interrupted in their strategy for cross by their own client who said, do not go to the bank with the other counsel. I have the statements here in my possession. And so he appeared to have withdrawn the motion. But then there was again a caveat. We will still clarify with the Chief Justice. Give us up to Monday whether we will really withdraw the motion to go there together or not. And then Monday afternoon, they filed a manifestation. They realized perhaps their mistake. They now do not wish to go to the bank. That's the first point. Second point, Your Honor, is that is the first set of documents. The second set of documents now are those set of documents allowed already by the Honorable Impeachment Court through the Honorable Presiding Officer to be brought before this august body by this same witness as requested by Senator Drilon. And
that is a separate matter altogether.
Yes, and this is found on page 70.
That is not your concern. That's the concern of a judge of this court.
It is my humble submission, Your Honor, please, if you will please kindly allow.
Go ahead.
That in the same manner that the defense counsel would not wish to be dictated upon in their prosecution or defense of their client, in their defense of their client, the prosecution would also want to see to it that the search for truth is not hampered by technicalities. They themselves opened the matter about monthly statements. Senator Drilon merely pursued it, and Senator Drilon requested those monthly statements to be brought here, and the Honorable Presiding Officer allowed that.
Let Senator, the judge of this court, deal with that matter.
Yes, Your Honor.
You have finished your direct examination of this witness.
Yes, Your
The
Honor.
only issue was whether you go to the bank to examine the monthly statements, or they will produce the monthly statements, and if you are not satisfied about the authenticity or accuracy or integrity of those bank statements, that will be a matter that can be decided again by this court. All right?
Just a final manifestation. I was merely discharging my duties to Your Honor.
I know that.
As an officer of the court, to assist the court in keeping track of the proceedings. In fact, I will end, Your Honor, with a last manifestation that there is a third set of documents, those requested by the Honorable Gentleman from Cebu, which the Honorable Presiding Officer also allowed. Thank you, Your Honor.
We are quite aware of this, even if we are 88 years old. I assure you that. So please, limit yourself to your role as a prosecutor, and I'm sure that the judges in this Senate can take care of their problems.
Thank you, Your Honor.
Understood?
Yes, Your Honor.
Okay.
Thank you.
So that we will not bog down in this incidental arguments. So, counsel, for the defense, what is your objection now?
Your Honor, please, before we go into that, maybe be allowed to state for the record, Your Honor, that when we read the matters we stated a while ago, that is not our opinion, Your Honor. It is on the basis of the transcript of the stenographic notes, pages 69 to 70, which carries the statement certified true correct, Antonia P. Barros, Director 3, Legislative Records and Archives, Your Honor. The same holds true with Section 69. I just wanted to make of record that we did not invent these occurrences, but this is borne out by the records of the case, Your Honor.
Thank you.
Thank you, Your Honor. Our objection is the witness. We are through with the witness had been presented. She was subjected to direct examination. After the direct examination, we conducted the cross, and after the cross, we are through with the witness, Your Honor. We do not know in what capacity the recall of the witness is made. There is no motion, there is no ground, there is no justification whatsoever.
There was a request by a member of this court for the recall of this witness, and that is a prerogative of a member of this court, according to our rules, to ask questions, clarificatory questions from the witness. I do not know what is in the mind of the member of this Senate in requesting for the recall of the witness. I cannot control, as a presiding officer, any member of this Senate sitting as an impeachment court to perform his job as a member of the Senate as a body of jury to try this case.
That is, if we may be allowed to say something, Your Honor.
Yes.
That is our apprehension, Your Honor, and very real. Because every time we make a manifestation or an objection as against the direct examination or examination conducted by a member of this court, we are overruled. And this is because we cannot object. So what will be our remedy if the judge, Senator, Your Honor, proceed to ask questions which to us are objectionable? We cannot just immediately go to the Supreme Court for a relief against that irregularity, which to our mind is very, very irregular. Because they are not merely acting as judges, Your Honor. They're practically appearing to us as private prosecutors. I hope we are pardoned for that, Your Honor.
Wait, Mr. Counsel. As I said in my opening statement, this is not an ordinary court. We are legislators assigned to perform a function outside of our function as legislators. We are not one mind. We are 23 minds in this court. That is why I called it a body of jurors. And if anyone is interested to find out what's the meaning of a juror, you are free. It's in the dictionary. Now, anyway, as a body of jurors, each one has his own perceptions and interests. In this case, to be able to make a judgment, a final judgment on this case. And I am not in a position to deny that right to any member of this body of jurors. So let the senator from Iloilo ask his question.
We have asked the question, Your Honor, but before we proceed any further, just to clarify, the record will show that all of this arose first out of the questions of the presiding officer to this witness. That is found on page 61 of the transcript. And on top of page 62 of the transcript, let me quote it. It says, Mr. Cuevas, in view of the answer of the witness, Your Honor, may we respectfully request that the statement of account covering these periods 2005, 2006, 2007, 2008, 2009, 2010 be produced by the witness at the most convenient time, considering her condition now, Your Honor. Our purpose, Your Honor, is to show that this figure is not made in one single deposit and one single withdrawal, Your Honor. And then the presiding officer said, and I quote, all right, so the witness is instructed by this court or ordered by this court to produce the documents that the defense counsel requested. So all of these statements of counsel appear to be not supported by record. But having said that, I have a pending question on the witness, and has the witness brought these documents requested?
By the way, before the witness will answer, is this a peso account?
Yes, sir. It is a peso account.
The witness may answer.
Did you bring these documents?
Your Honor, if you're referring to the bank statements for 2005 to 2010.
The monthly bank statements.
Monthly bank statements. No, Your Honor.
Why?
Because my understanding and our understanding is that we are waiting for the final instruction whether we will present those documents to this court.
Yes, the presiding officer of this court has in fact instructed you to bring this document. So can you bring it tomorrow?
Right.
Madam Witness.
Yes, Your Honor.
With the permission of the gentleman from Iloilo. Yesterday, this court ruled that we will respect the TRO to the extent that that TRO covers the foreign currency deposit accounts. And that's why I will prevent any discussion of any foreign deposit account, because that is the ruling of this impeachment court. But as far as the peso accounts, which appears to be covered by the TRO of the Honorable Supreme Court, our ruling yesterday will not cover the peso account. And so therefore, you are ordered by this presiding officer to answer the question of the gentleman from Iloilo.
Sir, if Your Honor, please, the witness has said that he has not brought the document. In deference to her condition, may we request that, as per order of the presiding officer and the order of this court, that the witness come back tomorrow. We have no choice but to ask her to come back tomorrow to bring these documents, because he didn't bring it this afternoon, Your Honor.
Mr. Prosecution, what is your pleasure?
Maybe we manifest, Your Honor, that in case he gives birth, can she send a...
No, just answer the question. Do not make any more dramatics.
Yes, Your Honor.
What is your position?
We submit, Your Honor.
All right. The defense.
We cannot object, Your Honor. That is the order of this honorable court. We will willingly submit. Submitted, Your Honor, to the discretion of the court.
The witness is directed to bring the requested records tomorrow afternoon at 2 o'clock. Tomorrow at 2 o'clock in the afternoon during the trial of this case at that time.
Mr. President.
The gentle lady from Taguig.
Mr. President, just a clarification. Given that the monthly statements are now the subject of the subpoena or the order to the witness, instead of a voluntary offer of the defense, given their manifestation that they, upon consulting with their client, they will no longer need to go to the bank and to look at it with prosecutors. I would just like to raise a question. It is not an objection, it is just a clarification. If the witness produces the monthly statements, how is this relevant to Article 2, which is the declaration of the SALN ended December 31? I just want to be sure that we do not clutter the court with information that is unnecessary. We need to focus on what the objective is, and that is to determine if an accurate and complete statement of accounts were made in the SALN. My understanding of the SALN is that the declaration must be based on December 31. So I would just like to know from the prosecution if the monthly statements is relevant to their defense of Article 2.
That is correct. But the understanding of this chair is that all evidence that's going to be presented will be in connection with paragraph 2.2 and 2.3 of Article 2, 2.2 being disclosure of the SALN, and 2.3 being non-inclusion of assets. The purpose of allowing those documents will only be limited to the determination of whether there are assets or peso assets, currency assets, cash assets of the respondent for the specific years covered that were not included in his SALN, and not to be authorized to be used in connection with 2.4 for in the mind and understanding of this presiding officer, paragraph 2.4 of Article 2 is actually non-existent allegation that is capable of being proven by any evidence that will be presented in the course of this trial. So ordered. Gentleman from Cebu.
Preliminarily, may I remind the court that it was the defense counsel that offered the monthly statements. We never asked for it. And I think Senator Judge Trilon just said, well, if they're offering it, it must be useful in their defense, because they would not have offered it if it would have been useful to the prosecution. Anyway, not being a lawyer, I hesitate to go further into arguments like this. Now, the subpoena, Ms. Dizon, that you were sent yesterday had to do with producing certain documents, including accounts, savings, current, time deposit, CDs, settlement accounts, investment management and trust accounts, unit investment trust funds, mutual funds, etc. Did you bring those documents with you?
Your Honor, I have with me the bank statements showing the balances of the account of the current account previously subpoenaed, the 14458036061, for the period ending December 31, 2002, 2003, 2004, and 2011.
Your Honor, please, without being disrespectful to
go ahead.
Senator Osmeña,
Yes.
Your Honor. There is a subpoena addressed to the witness, Your Honor, which was issued by this Honorable Court, Your Honor, on the 13th day of February. We did not have enough opportunity to question the validity and legality of the subpoena, Your Honor, pursuant to the law on subpoena. But this afternoon at 2:55, Your Honor, we filed a motion to quash the subpoena, Your Honor. And it seems that this had not been brought to the attention of the court. There is no ruling on this particular objection, Your Honor, and on the request for the issuance of the subpoena. So we feel, with due respect to Senator Osmeña, that this will be very material, Your Honor.
Counsel for the defense, I would like to you to bear with me. The accounts are very specific here. Original or certified true copies of the account opening forms, documents, banks statements showing the balances of the accounts as of December 31, 2001, 2003, 2004, 2005, 2006, 2007, 2008, 2009, 2010, 2011. The word accounts suggest to me that it refers to the account in this is the BPI, no?
Yes,
The account in the Banco of the Philippine Islands, which was mentioned in the original subpoena. There is only one account. It's simply that the noun account here, instead of being singular, it was made plural.
Yes, Your
Correct.
Honor.
Correct? So, if it relates to that particular account, this chair will allow it. But if it goes outside that account, with due respect to the members of this court, I will not allow it. So ordered.
In this connection, Your Honor, may we, with the kind permission of the Honorable Court, Your Honor,
Proceed.
direct the attention of this court to the statement appearing in this subpoena and any and all other financial instruments by the Bank of the Philippine Islands, Ayala branch, in the name of Chief Justice. It is in this particular instance, Your Honor, that there seemed to be parallelism between this subpoena and a general warrant of arrest issued.
But the account is specific.
General search warrant, I'm sorry.
Yeah, I'm talking of the account.
Yes, Your Honor.
Because as the gentleman from Cebu already stated, if I open an account in a bank and I put 1 billion pesos in that account, I could make that 1 billion disappear by putting it in
different accounts.
Money placement or in savings account or in other similar instruments. And that is the thrust of the question of the gentleman from Cebu. And I think it's a reasonable demand, given the fact that our purpose here is indeed to find out whether the respondent has not included in his SAL an asset that is sprung from the account like the one with the Bank of the Philippine Islands, because it has been removed because it was invested in some other instruments. That is my understanding of the interest of the gentleman from Cebu.
No,
if we are going to prevent that, then we will become a party to wrongdoings. And I'm not about ready to cover up for anybody. So the witness may answer.
Yes, Madam Witness, preliminarily, Mr. President, just to clarify what has been said here regarding this issue, may I just quote from the February 9 journal of this court, Senator Drilon speaking, and he says, now Senator Osmeña is saying that apart from these accounts, there could be other monetary instruments which were existing as of December 31st of any particular year to show a difference between what is stated as assets in the SALN and what actually exists, whether in the form of a checking account, a savings account, time deposits, and other monetary instruments as of December 31st, ending 2010.
Related to these accounts.
That is correct.
And linked with these accounts.
That is correct.
Or flowing out of these accounts.
That's right, Mr. President. So, on that basis, Ms. Dizon, did you bring with you the requested or the subpoena documents?
The only documents that I have with me, Your Honor, aside from the ending balance or the previous years, the 2005 and 2000 up to 2010 that were submitted last Thursday, I have with me the bank statement showing the balances of accounts as of December 2002, 2003, 2004, and 2011.
All right. So, any related time deposits?
There is none, Your Honor.
None exists.
None exists, Your Honor.
Certificates of deposits?
There is none, Your Honor.
Settlement accounts?
There is none, Your Honor.
Investment management and trust accounts?
There is none, Your Honor.
Unit investment trust funds?
There is none, Your Honor.
Mutual funds?
There is none, Your Honor.
So I was wondering, why is the defense so hepped up about this kung wala naman? Anyway, I thank...
I thought you are questioning the witness, not Justice Square. But
no, I was questioning Senator Drilon. I was Senator Drilon.
I'm sorry.
You were wondering why there was...
Let us avoid these things. Anyway, the witness has answered.
Yes.
There are no allied accounts, allied documents, whether time deposit, money placements or what mutual funds, investments or whatever, linked to that flowing and linked to that and linked to that account. So that's the answer. Already finished.
Thank you, Mr. President. May we just ask her to submit that list and for the committee secretary to take it in as evidence for the court.
The request is granted.
Thank you, Mr. President.
The witness will take it.
I have no more questions of this witness, and we shall await her return tomorrow for the request of Senator Judge.
Okay. Trial suspended for 1 long minute.
All right. Nag-adjourn ang Senate for 1 long minute. At ngayon, kasama pa rin ho natin ang former Dean ng UP College of Law na si Dean Pacifico Agabin. Okay. Balikan ho natin yung pinag-usapan kanina, yung outburst.
Sige, go ahead.
Oo, yung tukol sa subpoena versus search warrant. Kasi kanina pinagdebatihan na nga nila, sabi ng defense panel, parang nagmimistulang
general
search warrant itong paghingi ng mga dokumento tungkol sa mga bank accounts ni Corona. Ang sabi naman ng panig ng prosekusyon, hindi naman ho parang general warrant ito dahil humihingi kami ng specific bank accounts from the bank. So, ang sabi na nga ni Senator Miriam Defensor Santiago, bakit pa tayo nagdedebate tungkol sa search warrant at sa subpoena, hindi naman nag-issue ng search warrant itong Senado. So, as sinasabi ni Senator Miriam, binabalik niya sa totoong issue at hand. Sabi niya, ang issue here is bakit naglabas ang prosekusyon ng dokumento na wala silang knowledge of, at ito ang naging basehan ng pag-issue ng subpoena nitong Senado. Is this really contemptuous ground for contempt ba ito on the part of the prosecution?
Well, hindi naman siguro kasi ang kamali kasi ng prosecution diyan, inattach pa nila yung mga dokumento na hindi naman nila alam kung totoong tunay o peke. Hindi na kailangan i-attach yun sa request for subpoena. Kailangan lang ilagay doon yung account number, yung name of the depositor, and the particular financial instruments na related sa account number na yan.
Hindi na kailangan parang in-attach itong photocopy na sinasabing peking dokumento.
Hindi na kailangan.
They should have just written, dapat kinopya na lang
itong mga account
dito.
Numbers na to.
Pero hindi ba sila tatanungin, saan nyo pinulot itong mga account number?
Ayun nga ang tinatanong, kaya ayun, sinabi nila it was given to them by a small lady or whoever. Pero kung hindi sana nila inattach yung mga dokumentong yun, wala silang kasalanan.
May dalawang...
Pero at least they were honest enough to tell the impeachment court na hindi nila alam kung peke ito o authentic itong mga dokumento ito. So, they should not be penalized for their honesty.
May dalawa hong pinunto si Senator Miriam na parang gigil na gigil siya. Unang-una, do you ask this court for a subpoena based on a tip from an anonymous source? At pangalawa, based on media reports. Ano ho ba ang dapat basihan pag humihingi ka sa korte ng subpoena?
Ang basihan na dapat merong personal knowledge yung humihingi ng subpoena sa mga sinasabi niyang accounts na yun.
In this case, yung mga bank accounts.
Kaya tama naman si Senadora na hindi nila dapat pagbasehan yung mga media reports or anonymous tips. Kasi wala silang personal knowledge
Pero ang sinasabi ho ni Senator Miriam, kahit na in good faith na isinumite ng mga prosecution lawyer itong mga unverified documents, hindi pa sila off the hook. Pwede pa silang makasuhan kahit na in good faith nilang isinumite itong mga dokumento na nakuha nila dito kay small lady.
Hindi pa sila off the hook insofar as a disbarment case may be filed against them.
What will be the issue here?
Wala pa naman disbarment case na nakafile sa kanila
Okay. Gusto ko rin pag-usapan po itong naging development kahapon. Si Chief Justice Renato Corona, nag-file po siya ng isang supplemental petition sa Korte Suprema at inirereklamo niya yung asal ni na Senator Judge Franklin Drilon, Osmeña, Kiko Pangilinan, Alan Peter Cayetano at TJ Gingona. Ano ho magiging epekto nito? I mean, karagdagan pa ito bukod sa 5 nakabimbing petisyon na tigilin itong impeachment process sa Senado?
Hindi naman siguro seryoso yan kasi we cannot say that anybody is free from bias. Kaya if you disqualify the senators on the ground of personal bias, disqualify sila lahat. Kasi lahat naman sila, maski tayo, meron tayong personal bias. Nung yung impeachment provision sa Constitution ay ginawa ng mga constitutional commissioners, alam na nila from the very beginning na yung Senado is composed of political leaders who are partisan. Kaya na-factor na nila yung bias na yon. Kung merong bias ang isang senador for the prosecution, ay meron ding countervailing bias ng kabilang panig for the defense. Kaya na-factor na nila yung mga biases ng mga politiko sa pag-create ng impeachment court.
In fact, Justice Cuevas openly sinasabi na niya yan. Kahit kahapon, Senator Drilon's witness, tinawag niya gano'n yung manager ng PS Bank. Again, which makes us ask Dean, ano ho ba ang parameters? How should the senator judge behave? How should he or she ask questions? Hanggang saan ho ba pwede ho ba siyang mag-cross-examine? Pwede siyang mag-direct exam? Paano ho ba?
Pwede kasi they are sitting as judges. And so, pwede silang magtanong ng clarificatory questions at kung ano mang relevant question ang gusto nilang tanungin sa witness as judges. Kasi they are sitting as judges.
Alright, time out na ho muna sa ating talakayan at puntahan natin si Ivan para sa karagdagang balita.
Tuloy-tuloy pa rin po ang balitaan dito sa GMA News TV. Niyanig ng magnitude 3.1 na lindol ang Ilocos kaninang alas 11 ng umaga sa monitoring ng Philippine Institute of Volcanology and Seismology of PHIVOLCS. Naitala ang epicenter ng lindol 29 kilometers southeast ng Vigan, Ilocos Sur. Sinabi pa ng PHIVOLCS, tectonic ang origin ng lindol. Wala namang naiulat na nasugatan o napinsalang ari-arian. Samantala, nagmahal na naman ng mga produktong petrolyo ng ilang kumpanya na langis. Kaninang alas 6 ng umaga, 50 sentimo kada litro ang idinagdag ng presyo sa unleaded, premium at regular gasoline ng Shell, Chevron at Total. 85 sentimo naman ang itinaas ng presyo sa kada litro ng diesel. Ang Shell at Chevron nagtaas din ng 85 sentimo sa kada litro ng kerosene. Panibagong oil price hike ay bunsod pa rin umano ng paggalaw ng presyo ng krudo sa world market. Wala pang abiso ang iba pang kumpanya na langis kung susunod sila sa oil price hike. At sa iba pa ring balita, posibleng pumalo. Ito ho, sa 300 milyong piso ang jackpot prize ng Grand Lotto 655 draw sa Miyerkules. Kaya naman inaasahan ng haba ng pila sa mga lotto outlet ng mga nais tumaya. Ayon sa PCSO, Philippine Charity Sweepstakes Office, inilagay nila ang estimated jackpot nito sa 295 million pesos. Pero mula nang lumagpas daw sa 100 million ang jackpot prize, palaging lumalagpas dito ang actual jackpot prize. Ang laki ng Grand Lotto jackpot, bunga raw ng 3 buwan na hindi ito napapanalunan, kabilang ng draw nitong Lunes. Nobyembre pa nitong nakarang taon nang huli itong mapanalunan. Ang pinakamalaking Grand Lotto jackpot umabot sa 741 million pesos na tinamaan ng isang balikbayan noong Nobyembre ng nakaraang taon. At yan po, iba pang balita sa oras na ito. Balikan natin ang talakayan natin. Kasama pa rin siyempre si Dean Pacifico Agabi. Vicky.
Okay, Dean. Itong si Congressman Umali ng prosecution, siya raw yung umano'y nakatanggap nitong anonymous document mula kay Small Lady. Kailangan ba niya i-explain ang mahusay ito bago makapag-proceed itong mga senador sa pagdinig dito sa mga testigo nila?
Dapat naman, as an officer of the impeachment court, it is his duty to explain to the impeachment court kung paano niya nakuha yung evidence na yon.
Paano yun? Sinabi ho niya na hindi siguro sakop ng CCTV yung naging pag-abot sa kanya. Baka limited lang ho yung view nitong CCTV at hindi na-capture yung mismong moment na naibigay sa kanya.
In fact, siya mismo sketch yung recollection niya nung meeting nila nung small lady.
Hindi pa, walang katiyakan kumbaga kung saan talaga inabot sa kanya. So, will the Senate Impeachment Court just take his word for it? Or magko-conduct ba sila ng further investigation para magkaroon ng credence itong mga lumalabas sa mga testimonies ng mga bank officials?
Well, ibang issue naman yung credibility ng evidence na yan, Vicky, sa issue ng obtention ng evidence. Kasi kung yung pagkuha ng evidence na yan ay labag sa batas, then baka hindi ma-admit na evidence yung mga dokumento na yon.
Meaning kung kinuha, let's say, ng sapilitan mula sa isang tao sa loob ng bangko, yun ang illegal.
Yeah.
Pero kung binigay sa kanya ng anonymous source, does that constitute itong sinasabi nilang fruit from the poisonous tree? Na hindi nila ma-entertain ito dahil na nga mali ang pinanggalingan nitong
unauthorized
evidence.
Yung release ng dokumento.
Yung fruit of the poisonous tree, applicable lang yung rule na yon kung yung kumuha ng evidence, ahente ng gobyerno. Yun ang punto ni Senator Lacson kanina. Na kung private person ang kumuha ng information na yan, in violation of the constitutional guarantee against unreasonable searches and seizures, admissible pa rin yung evidence na yon. Pero kung police or military or any government agent ang kumuha in violation of the unreasonable search and seizure clause, then hindi admissible yung evidence na yon. Yun yung punto ni Senator Lacson, citing a case decided by the Supreme Court.
So kung isang non-government entity, isang tao, isang small lady na walang kaugnayan sa gobyerno, ang kumuha nitong mga dokumentong ito mula sa PS Bank, Katipunan Branch, pwedeng i-admit pa ito as evidence.
Palagay ko, oo.
Although pwedeng kasuhan itong taong kumuha nitong mga
pwede siyang
dokumento.
kasuhan for violation of Republic Act 1405.
Okay, so matanong ko lang, curious lang ho ako, isn't it in the bank's best interest to say that the documents are fake? Kasi pag sinabi nilang authentic itong mga document na na-leak, hindi ba sasabog sa bangko yon dahil lumalabas na may breach ang kanilang security and confidentiality? At mas lalong makakapag-bankra nito dahil kung ako yung kliyente, bakit ako maglalagay ng pera dyan? Talagang anytime pala pwede ipuslit ang mga bank documents.
In other words, the bank has been negligent in having these documents leak out in violation of the confidentiality of bank deposits law.
But on the other hand, if they say it's fake, then wala silang sabit. Ang may sabit dito yung prosekusyon dahil sa kanila sasabog to.
Yeah. Kaya lang we should not put too much emphasis on confidentiality of bank accounts kasi alam naman natin kung ano talagang ginagawa ng mga clerk sa loob ng bangko Ginagamit meron silang computer na interline, bawat empleyado doon na may computer, na-access nila yung mga deposits Kaya madali actually ang ma-access yung mga bank accounts na yan.
So baliwala yung conversation yesterday na sino ang may susi, 2 tao lang makakapag-open itong mga Dahil I think computerized and it's pretty much centralized na talagang pwede mong i-access kahit sinong nagmaman ng booth.
At madali naman i-hack yung mga computer systems, not to mention the fact na for instance kung mag-issue ka ng cheque na drawn on one bank then to be deposited in the other, pwede nilang ma-access yung mga records yung dalawang bangko by means of interline. Kaya yung confidentiality na yan, that is highly theoretical.
Ang consequence po ng pinag-uusapan natin na to kung peke nga yung mga bank documents, all testimony related to those accounts will be stricken off the record. Ika nga po tatanggalin as if walang nagtumistigo tungkol po sa mga ito. Pero ang iniisip ko lang nailabas na nasa kaalaman na ng mga senator judges, ng publiko. Yung mga senator judges po ba, will they be told na o pag nagdesisyon kayo tungkol dito sa Article 2, hindi nyo dapat i-consider to ha kasi stricken off the record to. Ganun po ba mangyayari? Paano pong magiging impact nun sa final judgment?
Kung peke talagang dokumento, bakit nila i-consider yung dokumentong yon?
Pero inamin ho ng mga bank executives mismo na yes, may account na ganyan. Oo, pero yung mismong dokumento ay peke. Paano ho ba magiging timbang?
Pero kung yung mga entries doon sa pekeng dokumento kapareho sa entries, yung figures ng original document, pwede pa nilang i-consider yon.
That's why I want to find out, actually, Ivan, kung, di ba, paulit-ulit na lang sinasabi kahapon, parang peke yung dokumento, peke. I wanna know, ano ba talaga yung difference ng peke tsaka sa original? Kasi baka naman pareho lang naman ng figures, maybe nagkaiba lang sa handwriting or something.
O iba yung font.
Yes, iba yung, pero kung pareho yung nilalaman, pareho yung balance, pareho yung dates, pareho yung account numbers, kahit na sinasabi nating fake, it's a reproduction of the original.
Not only that, Vicky, bago malaman natin na peke yung unang dokumento, dapat mailabas yung original. Ano?
Yes.
Ay, pag mailabas na yung original at makompare nila at pareho yung figures, edi yung mga figures sa original ang gagamitin sa Senado, imbes na yung figures sa peke.
But all these things came about because of this, sinasabi nilang anonymous document na dubious ang pinanggalingan. Masasabi ba natin lahat nitong pinag-usapan natin, lahat ng totoong balanse na lumabas sa mga testimonya, mababasura? Dahil ang pinagmulan nito ay itong fruit from the poisonous tree, itong dubious na document na nanganak ng mga testimonya na hindi dapat talaga nangyayari in the first place dahil in the first place, dubious na nga itong document na ito na lumabas.
Yun nga, depende kung paano nakuha yung fruit na yan. Kasi kung ang kumuha ay government agent, kagaya na sinabi ni Senator Lacson, talagang hindi admissible yon. Kung ang nakakuha ay private person, admissible yung evidence na yon kasi mayroon ng decision ng Supreme Court, yung sinasabi ni Senator Lacson, People versus Marty. Ito yung kaso na mayroong isang supplier ng marijuana nag-ship sa forwarder yung isang box ng marijuana. Nung nakarating yung box sa forwarder, naamoy ng forwarder na parang marijuana nga. Binuksan niya, yung marijuana nga. Report niya sa NBI. Kaya na-arresto yung shipper and then ang depensa niya it was illegally obtained by this forwarder. Sabi ng Supreme Court, hindi, kasi itong forwarder na ito ay private company and a private person. Kaya admissible yung evidence na yan.
Pero ano nangyari kay forwarder? Nakasuhan ba si forwarder dahil hindi niya dapat ginawa yun?
Kasi naamoy lang niya na mayroong marijuana
okay. Sige ho. Pero ang tanong ko ngayon, along those lines, sino naman yung maglalakas loob na sabihin, ako actually nagbigay ng bank documents kay Congressman Umali? Syempre makakasuhan din ako. So bakit lalantad yung taong ito? Which brings us back to the same thing.
Paano natin madedetermine kung peke o tunay?
Kasi sino naman ang maghaharap, di ba?
Yeah, madedetermine kung peke o tunay by bringing out the originals.
Pwede bang i-invoke itong ano ba yun? Witness, state witness? Pwede ba yun? Gawing state witness itong kung sino man ang nakakuha nitong bank documents na ito?
Oo, pwede. Kasi yun ang ginagawa ng gobyerno most of the time. Pag ginawa ng state witness at mabibigyan ng immunity, hindi na pwedeng makasauhan.
Kasi tulad nga na nabanggit mo, Vicky, hindi ilalabas ng bangko yung original. Sila lang may original, presumably. Hindi nila ilalabas yun dahil against nga sa interest nila.
So, makakasuhan naman siya ng bangko, no? Kung let's say na-prove na isang insider ang gumawa nito at nag-leak nitong mga bank documents ni CJ Corona, siya naman ang makakasuhan ng bangko.
Siyempre, makakasuhan ng administrative at criminal case.
But is the Senate Impeachment Court, do they have the authority to grant this person immunity, this small lady immunity? Kung sakasakaling magpadala
I doubt it. Usually, yung nagbibigay ng immunity, either the ombudsman or the Department of Justice. Hindi ako sigurado sa Senate Impeachment Court.
Oho. Ang medyo nagtaka ako kahapon sa testimony kahapon, parang hiningi ni Justice Cuevas yung mga detalye tungkol naman sa bank account ni Tupas. Ano kaya yung kinalaman? Ano kaya yung tinutumbukan niya rito? Bakit hinihingi pati yung mga bank account ni Tupas kung meron man dito sa PS Bank Katipunan branch?
Oh, no, that is highly irregular and of course it is irrelevant.
Kaya na nga ho hindi pinagbigyan.
Hindi na dapat pinayagan ng Senado yung mga ganyang questions.
Siguro, Ivan, pwede natin pag-usapan yung naging press release ni CJ Corona kahapon. No? Minsan lang magsalita si Chief Justice Corona tungkol dito sa impeachment proceedings, pero kahapon naglabas siya ng statement sa media at sinabi niyang the impeachment trial has become an inquisition and some senator judges have lost the cold neutrality of an impartial judge. Do you agree with this? Parang nagmistulan na bang inquisition itong ating impeachment trial?
Well, ang assumption niya diyan yung impeachment court parang sa judiciary na mataas ang standard nila sa judiciary. The judge has to have the cold neutrality of an impartial judge at tama yon. And then as to integrity, ang taas naman ng standard nila kasi ang standard nila it must be like Caesar's wife. Maalala niyo yung sinabi ni Shakespeare about Caesar's wife.
Naku, hindi ko
Sabi ni Caesar, my wife must not only be free from suspicion, she should be above suspicion. Yan ang pinakamataas na standard sa mga public servants.
I-define lang po natin.
Ang standard sa mga politicians ay mababa. Kasi a politician cannot be accused of partisanship because that is precisely the essence of politics. But a judge can be accused of partisanship. Kaya we should take into account the different ethical standards applicable to the judges and applicable to an ordinary politician.
Paliwanag lamang po natin sa ating mga manonood, ano ho ba ibig sabihin ng inquisition?
Yung ano?
Inquisition. Yung sinasabi ni Chief Justice Corona nga na parang ganun na ang kinalalabasan ng impeachment trial.
Oo. Yun ang point of view nila kasi it turns out pala na aside from the impeachment proceedings, ina-investiga pa yung mga yung BIR, yung mga tax returns, not only sa kanya, kundi mga miyembro ng pamilya niya. That is really an inquisition if from the family's point of view.
Pero from the point of view naman of Commissioner Jimenez, nung nagsalita siya sa hearing, sabi niya, siya naman yung mapuputukan kung hindi niya ginawa yung kanyang duty, no? Which is to go after tax evaders.
Kumbaga, nandyan na yung ebidensya, hindi siya umakto.
Oo, hindi siya gumagalaw. So I guess she's doing it out of her own, yung kanyang professional calling. Tapos, sinabi rin ho ni Chief Justice Corona na itong sina Drilon, Osmeña, Pangilinan, Alan Peter Cayetano, TG Ginggona ay medyo tumutulong daw sa mga prosecutor. Do you think they've been crossing the line sa mga nakikita natin, yung kanilang line of questioning, etc.? Maski
totoo yun, they cannot be faulted for that because yun nga, yung impeachment court is precisely composed of politicians who may have their own partisan biases and their own affiliations. Pero naipaktor na yan sa paggagawa ng impeachment court. Kasi kung maski majority ng politicians sa prosecution at minority sa defense, there will always be someone in the impeachment court who will take up the cudgels for one of the parties.
Yeah, in the same manner, the other side can also invoke the same accusation against the other side na may mga pro-corona din naman na nagsasalita pa minsan-minsan. Yeah. And based on yung naging botohan kahapon, did you expect this 13-10? 13 bumoto pabor sa TRO ng Korte Suprema.
At kanina parang in-explain ni Presiding Officer Enrile yung kanyang boto na I will respect the Supreme Court with its power of judicial review.
Pero yung issue na binutuhan nila it's a legal issue Vicky. The legal issue is whether foreign currency deposits are absolutely prohibited from being disclosed to any public entity except with the consent of the depositor. Masyadong klaro yung foreign currency deposit law Kaya palagay ko yung majority took into account the absolute nature of the provision of the foreign currency deposit law.
So hindi natin masasabi
pabor sila kay prosecution or pabor sila sa respondent, palagay ko hindi.
So hindi ito indicative of how they will be voting eventually regarding the articles of impeachment. Hindi natin masasabing sneak preview ito kung paano magiging takbo ng botohan mamaya kung to convict or to acquit Chief Justice Corona.
To a certain extent, indicative. Pero hindi lahat sila na bumoto sa majority, I think, would necessarily vote in favor of the defense. The same holds true for the minority. They will not necessarily vote for the prosecution because they must have taken the provisions of the law into account.
Okay. Time out muna tayo sa ating talakayan. Balikan natin si Joseph Morong sa Senado. Joseph, kumusta na si Senadora Miriam Santiago? Inalta presyon na naman yata, ano?
Oo, tama ka dyan. At kasalukuyan nga ay umuwi na itong si Senador Miriam Defensor Santiago matapos niyang ma-high blood. No? Ayon dun sa kanyang staff ay 170/90 yung naging blood pressure nitong si Senador Santiago. Ito ay matapos niyang tila mainis doon sa prosecution dahil ang sinasabi is parang peke daw yung gumagamit na attachments or ebidensya tungkol doon sa bank accounts ni Chief Justice Corona. Sabi ni Senator Santiago, hindi pwede yan sa isang korte kung nangyari yan sa isang regular na court. Di ba matatanda natin na trial court judge itong si Miriam. At kung nangyari daw yun sa kanyang korte bilang trial judge, ang sasabihin lamang niya, Sheriff, bring this to the city jail. Parang ganun yung sinasabi niya na yung action ng paggamit ng mga peking dokumento ay hindi pinapayagan. Sinight ni Senator Santiago yung dalawang instances na may mga abogado na una, hindi nila alam na ginamit na ay peke at yung ikalawa ay alam na peke pero binigay pa rin sa korte. Sabi ni Miriam, walang exception siya. Pag minislead mo yung korte, ay medyo tagilid ka na dyan. Kanina ay bago siya umuwi, nagkaroon muna ng pagkakataon ng ilang mga taga-media na makausap itong si Senador Santiago at narito ang kanyang pahayag.
Ang natuklasan ko ganito. Unang sabi nila, merong tao o babae nagbigay ng impormasyon sa amin tungkol dito sa secret bank accounts na ito. Hindi pwedeng magbigay ka ng subpoena na sinabi lang ng abogado, merong nagsabi o merong nagbulong sa akin. Hearsay evidence yun. Pangalawa, meron pang paragraph na sabi ng ibang media nga, ganito, ganyan. Hindi ka naman pwedeng mag-issue ng subpoena, ulit base lang doon sa sinabi ng isang reporter o kolumnista.
Even Vicky, that sa pagdinig, malamang napanood nyo rin, no? Sinabi nitong si Senator Miriam Defensor Santiago, yung sinabi ng prosecution na duty nila na ibigay itong mga dokumento na nakita nila. Ang sabi ni Senator Santiago dyan, duty my foot, it is your liability. So matatapang na salita ang sinabi nitong si Senator Santiago kanina sa pagdinig. Pero on a lighter note, 420 na, no? Ang sabi nitong si Senate Presiding Officer Juan Ponce Enrile ay susubukan daw na tapusin yung 5 dahil bukod sa birthday niya ay Valentine's Day daw. Bibigyan daw ng pagkakataon yung ibang mga tao na makasama yung kanilang mga boyfriends or girlfriends o kahit yung mga asawa. Narito yung kanyang payag before the trial started this afternoon.
Thank you very much, and happy Valentine to you and to the country.
Sir, what's your birthday wish?
My birthday wish, gusto ko happy kayong lahat.
So sir, maaga matatapos ngayon dahil may date kayo at may date kami?
Ha?
Sa hearing.
Wala akong date. Ang date ko mamayang gabi ay ang aking pamilya.
So date pa rin yun, sir.
Ha?
Date pa rin yun.
Are we finishing up early today, sir?
Dapat 5 o'clock tapos na. Hindi rin.
Oo, siguro matatapos tayo ng 5 o'clock. Para makasama ninyo ang mga boyfriend ninyo at mga girlfriend ninyo.
Sir, konti lang sundot dun sa kagabi. Ayan nga, malalaman natin kung matutupad yung birthday wish itong si Senador Enrile. Kasi kung nakikita nyo,
mas galing yung suggestion
ang usapan. Ano na?
Mukhang galing sa reporters yung suggestion na tapusin na maaga.
Well, actually, pero he concurred.
you concurred, ha? Joseph, isa lang. Have we heard from Congressman Umali tungkol dito sa
small lady
tall order na kailangan niyang ipaliwanag kung paano niya nakuha yung dokumentong hawak niya?
Kanina ay nakuna natin itong si Representative Umali before the trial, at ang sinabi niya, number 1, gusto niya makita yung hawak na CCTV ng Senado dahil ang sabi niya baka naman hindi lahat ng areas ng Senado ay covered. And he also said na he stands by his story na merong small lady. Ngayon, sabi namin, ano po yung proof ninyo para sabihin na yung small lady ay talaga nag-i-exist? Sabi niya, well, I have no proof except my word as being a lawyer. So mukhang pinaninindigan nitong si Representative Umali yung kanyang testimony. Sinasabi niya sa korte na merong small lady na nagbigay sa kanya ng documents nung nandito siya sa Senado. Although kahapon, in a matter of context, sinabi ng Senate Majority Floor Leader si Tito Soto na wala namang nakita yung sa CCTV between 1 o'clock to 3:19 na small lady doon sa CCTV ng Senado. Ivan, Vicky.
Joseph, sino na ngayon ang mga witness na nakalinya dyan sa Senate Session Hall? Bukod dito kay BPI Manager.
Okay, bukod sa BPI, inaasahan din sana natin today yung taga PS Bank, itong si Annabel Chongson. Kasi katulad nitong sa BPI, ay pinahiningan din siya ng certain documents. Tingnan natin kung matatapos itong si BPI at kung if we can proceed. Pero bangko pa rin yung pag-uusapan natin. Ito yung mga bank documents, yung records ng mga bank documents itong si Chief Justice Renato. So at least maybe 2 witnesses today, Vicky. Okay.
So Joseph, inaasahan rin natin na dala-dala ng PS Bank Branch Manager itong original documents para maikumpara dito nga sa sinasabing peke document. At ngayon, magsisimula na ho ang impeachment proceedings. Balikan natin. Thank you, Joseph.
Mr. President, maybe ask the prosecution if they have another witness. But before that, the defense panel would like to have the floor, Mr. President.
If Your Honor, please. Today is February 14, Your Honor, the natal day of the presiding officer of this honorable court, Your Honor. In addition to that, it is Valentine's Day. Baka ho pwedeng ipahingi na ninyo sa amin ang araw na ito para naman makapiling namin ang aming mga minamahal sa buhay. Total, alas 4:25 na po eh. In short, I'm asking for a declaration of cessation of hostilities, Your Honor.
Thank you.
Hindi po maganda eh.
Okay. Majority Floor Leader.
Mr. President, the prosecution wants the floor, Mr. President, before we...
Yeah, Your Honor, we joined the manifestation of the defense. Happy Valentine's Day and happy birthday, Mr. President.
Thank you.
Mr. President.
Peace be with you.
Mr. President.
Senator Pangilinan, Mr. President.
The gentleman from Pampanga.
Mr. President, I just want to express my agreement with both the defense and the prosecution, and that I would like to say that because today is the birthday of our presiding officer, I think the work that he has done, his able steering of this procedure, Mr. President, he deserves this early suspension or adjournment of this trial. He has earned every peso ika nga, every second.
Thank you very much, Senator.
Happy birthday.
Thank you.
Thank you.
Happy birthday again to the Chief.
Thank you for being kind to a man on the departure room. The departure room.
Wag naman ho. Wag naman.
Majority Floor Leader.
Mr. President, may I be allowed to do some housekeeping chores?
Please proceed.
First of all, we received a memorandum from the prosecution In compliance with the directive of the court, the prosecution submitted yesterday its memorandum on the powers of the Chief Justice for the information of the court.
May we request that the members of the court be given a copy of that memorandum? That will be a guide for us if we come to the other articles of impeachment.
Thank you, sir. Yes, Mr. President. The clerk of court will do that. Also, Mr. President, the prosecution filed a manifestation on February 9 informing the court that it is temporarily discharging Ms. Marisa O. Bondoc, Corporate Secretary of the John Hay Management Corporation, from appearing before this court until further notice.
This is the prosecution.
Yes, Mr. President.
Will the prosecution bring this witness back to the court, or are you permanently discharging her?
Your Honor, we are permanently discharging her as our witness.
Why?
We feel that we don't need anymore to put her on the witness stand.
All right.
And because she has resigned already, Your Honor, from her post recently.
All right. The discharge of what's the name of the
Marisa Bondoc. Your Honor.
The manifestation of the prosecution to discharge permanently from this trial Ms. Marisa Bondoc as a witness for the prosecution is hereby granted.
Mr. President, in compliance with the subpoena duces tecum issued by the court, Mr. Noli D. Hernandez, Senior Vice President for Marketing of Mega World Corporation, submitted on February 8, 2012, his compliance. Annexed to the compliance are 9 documents concerning the Bellagio Golf View residences for the information of the court and the parties, Mr. President.
Any comment? Any objection? Hearing none, we note the compliance.
And finally, Mr. President, we are in receipt of a manifestation and motion from the Philippine Airlines dated and received February 9, 2012, requesting that they be given adequate time to collect and collate the documents required to be produced under the subpoena ad testificandum et duces tecum issued to them, and praying that they be granted such period deemed adequate by the court for the production of the said documents.
What is...
I move that the presiding officer rule on the motion, Mr. President.
What period are we going to give them?
We interpose no objection, Your Honor, to granting them sufficient time.
But what...
May we move for February 21, Mr. President?
Any objection? Well, notify the Philippine Airlines that the request is granted, but they will have to submit it that on or before February 21, 2012.
One final question from Senator Estrada, Mr. President, on the witness that will be presented tomorrow.
Thank you, Mr. President. Just a point of inquiry, Mr. President. May I know from this court if the bank manager of the PS Bank is coming back tomorrow? Ms. Annabel Chongson.
Manager of the PS Bank. Are we talking about the manager?
Yes, Mr. President.
How about the president?
I think they were summoned also, Mr. President, yesterday.
Well,
they are here.
We will instruct the president of the PS Bank and the manager of the PS Katipunan branch to appear in this court in the trial of this impeachment case at 2 o'clock in the afternoon of
February 15.
Wednesday, Mr. President. Tomorrow.
Wednesday, February 15.
February 15 at 2 o'clock in the afternoon.
Thank you, Mr.
Thank
President.
you. Mr. President, may we ask the Sergeant at Arms to make an announcement?
Sergeant at Arms is, must now make an announcement.
Please all rise.
All persons are commanded to remain in their places until the Senate President and the senators have left the session hall.
I move that we adjourn until 2 o'clock in the afternoon of Wednesday, February 15, 2012.
Is there any objection? The trial of this impeachment case is hereby adjourned until 2 o'clock of Wednesday, February 15, 2012.
ng impeachment trial ngayong araw nito, kakasabi lang ni Joseph kanina. Tingnan natin kung matupad yung hiling ng mga senador. Ayan, mas maaga pa sa alas 5 ang naging adjournment.
Sa pambihirang pagkakataon ay nagkaisa ang depensa at ang prosekusyon.
Ceasefire nga daw eh.
Oo, yes. Nabigyan naman ng panahon itong si Presiding Officer Juan Ponce Enrile na ipagdiwang ang kanyang 88th birthday.
And in the spirit of love, ika nga daw, cessation of hostilities muna sa pagitan ng prosecution at ng depensa. At
nag-agree rin itong mga senator judge natin na excited na rin umuwi para makapili ang kanilang mga mahal sa buhay. At sabi na nga sa interview sa media nitong si Presiding Officer Juan Ponce Enrile, ang date lang niya ngayong araw na ito ay ang kanyang pamilya.
At gusto niya happy tayo lahat.
O ang wish niya ay maging happy tayong lahat. Matanong natin ang ating panauhinhon na si Dean Pacifico Agabin. Sino kaya ang naging happy ngayong araw na ito? Ano bang na-accomplish natin ngayong araw na ito dito sa Day 17 ng impeachment trial?
Palagay ko lahat sila Vicky happy kasi Valentine's Day. Siguradong mayroon silang date mamayang gabi kaya happy sila lahat.
Pero may na-accomplish ba sila ngayong araw na ito?
Mayroon naman konti pero hindi kasi dami nang na-accomplish kahapon.
Isang hanging question lang gusto ko itanong kanina. Going back to Congressman Umali, paano ho niya patutunayan yung kanyang kwento tungkol sa dokumentong napunta daw sa kanya? Ano kayang pwede niyang gawin tungkol dito?
Hindi naman niya mapatunayan na talaga kung hindi nakuha ng Circuit TV yung pagbigay sa kanya ng envelope. In the first place, hindi natin alam kung totoo yung sinasabi niya o hindi. Kaya siguro kung nakita niyang nakuha ng Circuit TV, hindi siya makapagsinungaling. Pero kung hindi nakuha, pag sinabi niya na it was given to him by a small lady, tapos na yung explanation niya.
They just have to take his word for it. At talagang he's standing by his story. Sabi niya, talagang isang small lady ang nag-abot sa akin. Baka hindi lang nahagip nitong CCTV, pero yan ang story ako and I'm sticking by it.
So mukhang isa yan sa abangan natin in open court kapag nagpaliwanag na si Congressman Umali.
Alright, so on that note, maraming salamat sa legal expert na ating nakasama ngayong hapon, si Dean Pacifico Agabin. Thank you very much.
Thank you, Dean. Thank you. Happy Valentine's po.
Happy Valentine's.
Thank you.
At yan po ang mga pinakasariwang balita kaugnay sa impeachment trial ni Chief Justice Renato Corona. Ako po si Vicky Morales.
Huwag po kayong bibitiw sa patuloy na pagtutok ng GMA News TV sa makasaysayang paglilitis ng punong mahistrado ng Korte Suprema. Ako po si Ivan Mayrina.
At ito po ang The Chief Justice on Trial.
Ang pagiging tapat ay hindi pampaminsan-minsan. Ang pagiging tapat ay paraan ng pamumuhay.